Namaskar, and a very good evening to one and all. In the words of John J. Chapman, one of the deepest impulses in man is the impulse to record, to scratch a drawing on a tusk, or keep a diary. The enduring value of the past is, one might say, the very basis of a civilization. On that note, I, Siddhant Mishra, Judicial Magistrate First Class, Odisha Judicial Services, and
I, Shri Samanta, Judicial Magistrate First Class, Odisha Judicial Services,
on behalf of the Honorable High Court of Orissa, extend our warm greetings to National Conference on Judicial History and Archiving.
We are fortunate to have with us Honorable Sri Justice Shripathi Ravindra Bhat, Judge, Supreme Court of India, respected Madam Srimati Lalit Mohini Bhat, Professor Partha Chatterjee, Professor Emeritus of Anthropology, Columbia University, and Honorary Professor, Center for Studies in Social Sciences, Calcutta, Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, Honorable Judges of the High Court of Orissa, former judges, respected members of the bar, delegates, discussants and paper presenters, officers of the registry, officers of the Odisha Judicial Academy, judicial officers, and members of print and electronic media.
May I now request my Lord Honorable Chief Justice Shripathi Ravindra Bhat, Judge, Supreme Court of India, to kindly adorn the dais, and I request respected Registrar General Shri Pratap Kumar Patra to kindly conduct his Lordship to the dais.
May I now request respected Professor Partha Chatterjee, Professor Emeritus of Anthropology, Columbia University, and Honorary Professor, Center for Studies in Social Sciences, Calcutta, to kindly adorn the dais, and I request respected Additional Director, Odisha Judicial Academy, Sri Badri Narayan Nanda, to kindly conduct our esteemed guests to the dais.
May I now request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly adorn the dais, and I request respected Registrar Vigilance, Shri Akhil Kumar Paschim Kabat, to kindly conduct his Lordship to the dais.
May I now request Honorable Sri Justice Debabrata Das, Judge, High Court of Orissa, and Chairman, Record Room Digitization Center Committee, to kindly adorn the dais, and I request respected Registrar Inspection Sri Prabhakar Gantia to kindly conduct his Lordship to the dais.
May I now request Honorable Dr. Justice Sanjeev Kumar Panigrahi, Judge, High Court of Orissa, and Member, Record Room Digitization Center Committee, to kindly adorn the dais, and I request respected Coordinator Arbitration Center Shri Soumyak Patra to kindly conduct his Lordship to the dais.
May we now seek permission of the Honorable Chair to kindly declare the event as open. Thank you, my lords. With this, we now declare the event as open. In the words of Thomas Jefferson on archiving, that is, let us save what remains, not by walls and locks, which fence them from the public eye and use in consigning them to the waste of time, but by such a multiplication of copies as shall place them beyond the reach of accident and in posterity. And in this spirit, we now begin the inaugural session. May I now request Honorable Sri Justice Debabrata Das, Judge, High Court of Orissa, and Chairman, Record Room Digitization Center Committee, to kindly present the welcome address to the august gathering. My Lord, please.
A very good evening to all present here on this grand occasion. Honorable Sri Justice Shripathi Ravindra Bhat, Honorable Judge, Supreme Court of India, and gracious Madam Mrs. Bhat, Honorable Dr. Justice S. Muralidhar, the Chief Justice of High Court of Odisha, and gracious Madam Usha Ramanathan, Honorable Sister and Brother Judges of the High Court with their gracious spouses, our distinguished guest, Dr. Partha Chatterjee, Professor Emeritus and Anthropology and of Middle Eastern, South Asian and African Studies, our guests and discussants, Dr. Suranjan Das, Dr. Prabhu Prasad Mahapatra, Dr. Nivedita Mohanty, Dr. Sanjay Garg, Sri Lalatendu Das Mahapatra, the Director Archives, Registrar General and his team, Member Secretary, Odisha State Legal Services Authority, Director, Odisha Judicial Academy, learned members of the bar, including learned Additional Solicitor General, members of print and electronic media, ladies and gentlemen. It gives me immense pleasure in welcoming all to this grand occasion. We feel particularly honored and gratified that we have Honorable Sri Justice S. Ravindra Bhat, Judge Supreme Court of India, in our midst today to grace the occasion. My Lord, we welcome you to this conference on Judicial History Project Preservation and Archival. I must say at this juncture that, sir, in your absence, we would have been deprived of seeing the rainbow with all the colors in this auditorium today evening, sir. We are fortunate to have Dr. Partha Chatterjee, Professor Emeritus, Anthropology, among us as our guest. We welcome you, sir, from the core of our hearts. I welcome all the discussants for sparing their valuable time and energy for this conference to be meaningful. We are grateful to your earlier contribution for preservation of judicial history in Odisha. I welcome all the participants also. Yours being an assemblage of erudites and scholarship, it is hardly desirable on the part of a layman like me, even though the head of the committee, to intrude into your deliberation. But being duty-bound, I would like to start with the quote of Kofi Annan, who once said, "Knowledge is power, information is liberating, education is the premise of progress in every society, in every family." In the light of the above quote, I would say that spreading of knowledge through preservation of history has a significant role to play in the betterment and development of the nation. The potential of a person to attain knowledge, protect, and pass it on to the next generation makes the person powerful. Knowledge should always be shared too. It enables the person to use them for their benefit. After Honorable Chief Minister of Odisha, Mr. Naveen Patnaik, laid the foundation stone for the Center for Archives, Judicial Archives, we also celebrated 1 year of completion of the said archives. In an era of increasing enthusiasm for revisiting the past by exploring more unexplored areas, the need of preservation of historical records and their collation and shifting is of paramount importance. In this regard, digitization has given the best opportunity to safeguard the fragile old records and to reduce the pendency of the cases to the Indian judiciary. Preservation of judicial history is very important as it gives a sense of identity along with the continuity of the past history and the culture for future generations. Through preservation, we learn the level of development, knowledge, and thoughts of our past. It provides life to our past and becomes a source of evidence. Since the modern judicial system in Odisha started with the annexation of Odisha in different phases, from second half of the 18th century, both the High Court of Orissa and different district courts have left with us millions of invaluable court cases and documents, which would not only require archiving, but also consultation for reconstruction of the judicial and legal history of the state. Having realized the utter need for their potential use, Honorable Dr. Justice S. Muralidhar, our beloved Chief Justice, mooted the idea of setting up a judicial archives consisting of all fragile records of the courts till 1950. This bulk of documentary heritage inspired Honorable Chief Justice to embark upon a mega judicial history project, which constituted setting up of judicial archives for preservation of these records, upgrading the Museum of Justice, and writing the judicial history of Odisha. I, on behalf of the committee, extend our hearty thanks to him for getting us associated in this mission. An archive is not only the repository of the documentary heritage of an institution, but also its collective memory, and passive witness of its historical past. Therefore, archiving the records of historical value and administrative importance should be one of the primary objectives of every institution. The setting up of the Center for Judicial Archives by the High Court of Orissa is undoubtedly a historic step which has been thrown open all its fragile records to the public for consultation. I am proud to say that it is the first judicial archives in India. The journey of Center for Judicial Archives just started on 1st of May 2022 with acquisition of more than 50,000 fragile records and equal number of records identified and ready to be transferred to our custody. It has made a milestone in the history of archives in India by such rapid progress of acquisition within a short span of time. By keeping these court records in public domain, the center has allowed access to the scholars for the first time in the history of judiciary in India. While the setting up of its own dedicated building, its activities have increased manifold. The entire work of preservation of archival records and upgrading the museum was entrusted to INTAC Odisha chapter. But before that, our Chief Justice desired to lead a team consisting of Brother Justice Sasikant Misra and Dr. Lalatendu Das Mahapatra, Director for Judicial Archives, to visit some leading museums, archives, and libraries in India to get an insight about their preservation, upkeeping of records, and digitization system for their possible adaptation here. The visit to these institutions provided them deep insight about preservation and digitization system of records and showcasing them of the gallery for the museum. Inputs have also been taken from the authorities of the British Museum by organizing conference through virtual mode. The work on the digitization of record on the arrival of Honorable Justice S. Muralidhar, in fact, got its acceleration. On this land of Lord Jagannath, under his leadership, the new RRDC building was planned and constructed. He gave the digitization initiative a new life by replacing the heart in the state of Odisha. I hope His Lordship would continue to so guide us in future days to come. We too assure you, sir, that the ball having set rolling under your towering leadership, it would continue in its march in the days to come. The agenda of the conference will include theoretical views of different experts, presentation of papers on judicial history, motivation through examples, interactive sessions, question and answer sessions. We are extremely hopeful that this conference is also going to be a great success, and we request for your support and cooperation in making it memorable and successful one. I am sure that we all will feel enriched with the knowledge after completion of this event. I welcome you once again to this conference and hope that you all will have a great time. Bande Utkala Janani, Jai Jagannath.
Thank you, my lord, for the warm and heartfelt welcome extended to our honorable guests and words of encouragement. May I now request the esteemed dignitaries on the dais to kindly release the book titled The Judicial History of Odisha, Volume 1. I request all the members of the Record Room Digitization Center Committee to kindly come to the dais for releasing the book.
May I now request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly address the august gathering. My Lord, please.
Good evening, Pranam. This is a very special moment for all of us in the High Court of Orissa. This is something that we've been dreaming about for quite some time, and it's finally happened. As Justice Devabrata Das was mentioning, the record rooms of the High Court of Orissa and the district courts were the impetus for us to even start thinking of this whole project of archiving, and from that to move on to a project of judicial history. We didn't expect, I think it was serendipitous that this whole judicial history project has happened as an offshoot of this exercise of digitizing of old records. I remember, and which is why I think it is so fortunate that we have Justice Ravindra Bhat here with us. He's been a very dear friend for many, many years. I remember the first time I went to the Berhampur District Court. Justice Shashikant Mishra was the district judge there. And after I saw the preservation in the natural state of records of over 200 years old in that district court, I remember sharing that excitedly with Justice Bhat when I met him next. And I know Justice Bhat has a very keen sense of history. So we are indeed extremely fortunate to have him preside over this first ever, I would think it's the first ever national conference on just judicial history organized by a high court. And I didn't think it was going to be possible during my time, but it has made possible. Thanks to, of course, my own committee, the RRDC committee, which has been completely on board, completely dedicated to this task, led by Justice Dash. And Justice Panigrahi is a member of that committee. So is Justice Sashikant Mishra, Justice Sanjay Mishra, Justice B.P. Satpathy. This is the committee that also is overseeing the Museum of Justice, which are members presenting papers and other experts will be visiting. We couldn't have thought of a project of this scale without the active support of the state government. The Chief Minister is known for reacting very positively to any initiative which preserves culture, heritage, and history. He is himself a person of deep learning and deep sense of history and the value of these efforts. And I must also mention the presence we have in our midst, Dr. Balakrishnan, who has been completely encouraging of all these efforts. So, more than a year ago, when the whole idea of this judicial history project was mooted, we received a very positive response from the government in a very short while. So, the three limbs, we have the digitization, we have the archiving of the records, which you will all see in the RRDC, which is very close by. We have the judicial history project itself, and then we have the Museum of Justice, which again you will all visit. I think this is probably a good example of interdisciplinary effort, the disciplines, major disciplines of law and history. It is indeed a very happy moment for us in the High Court that we have under one roof on one day so many historians. And joining us on this journey of unraveling the judicial history of Odisha, of course, and in that process probably the judicial history of the country. I have suggested to the Chief Justice of India that what we're doing here in Orissa with the old records and with the artifacts that you find in our district courts, if we could start similar initiatives in some of the major high courts, which would include, of course, the presidency courts, Calcutta, Bombay and Madras, and some of the older courts, Allahabad, and even Delhi and Punjab, I think it would be a very exciting moment for us, not legal historians, but persons in the law as well. Justice Das was mentioning, for us it's a learning our own past, how our own contemporaries in the pre-company times and company times and then British times handled cases similar to the cases that some of us are handling today. It would give us good insights into the interaction with society, law and society, and other sub-themes, politics and law, economics and law, sociology and law. I think these judicial records tell us many stories, and which is why, again, we are very fortunate to have with us Professor Partha Chatterjee. Sir, we really thank you for making your time available to be with us. He's one of our most eminent historians. He's authored, among many other books, this book on the Bhowal Sannyasi case, and I can't wait to hear him give his keynote address. I must also thank one other historian who's in our midst and who gave us a wonderful talk just 2 months ago, Professor Prabhu Mahapatra, who's here with us, and who's helped us organize the sessions, the themes of the papers that should be presented. We knew that the topic was very vast. We knew we couldn't cover most of it in a very short while, but we had to make a beginning somewhere. So these themes have been carefully selected. I must also acknowledge the help that we received from eminent historians in Odisha itself. One of them is here, Dr. Nivedita Mohanty. She's been helping us right from the beginning. And she's herself an author of a wonderful book on the history of Odisha, particularly the freedom movement. We've got many insights from all of them in revamping and rejuvenating the museum, and which we were confident enough to name as a Museum of Justice. This is just the beginning. We realize that we are at the edge of a shore, edge of a vast ocean. We're just making a beginning. We know it's a journey which has a long life of its own. We're beginning to build the Center for Judicial Archives. It will be a separate building just next to this Odisha Judicial Academy building, and where we will be able to scale up the efforts at digitization, preservation of old judicial records. And we are hoping it will tell us many more stories of our past and of our courts, of our laws. And it will be a learning experience for future generations as well. With that, I'm very happy that this conference has finally happened. And I'm hopeful that with the rich array of papers being presented, with some of the best historians of the country being so kind enough to be with us for these 1.5 days, I'm waiting to be completely immersed in those engrossing sessions that will follow tomorrow and day after. Thank you so much, all of you, for being here. Jai Hind.
Thank you, my lord, for sharing your valuable insights, and we are certain that the Judicial History Project and archiving will thrive under your tutelage. May I now request respected Professor Partha Chatterjee, Professor Emeritus of Anthropology, Columbia University, and Honorary Professor, Center for Studies in Social Sciences, Calcutta, to kindly present the keynote address to this august gathering. Sir, please.
Thank you. Distinguished judges, distinguished members of the legal profession, some of my friends, the interlopers, historians like me, and members of the audience. Thank you very much for inviting me to speak here at this rather unusual conference, I must say. This is not the usual venue, nor is it the usual topic for conferences most of the time. And that's one of the reasons why I decided these days I have more or less withdrawn myself from academic gatherings, but I decided this would be an interesting place to visit. So thank you very much for giving me this opportunity. The Odisha High Court, I gather, was set up in 1948. Now, but the judicial records in the archive, which it's now put together, those records go back to the early 19th century, including records of the district and other lower courts, as well as records from some of the former princely states of Odisha. Now, why are these records important? One possible answer would be legal precedent, because as we know, our entire judicial system is based on precedent. But we also know that precedents are usually cited from judgments of the higher courts, which are, as we all know, compiled in printed law reports, which line the offices of all lawyers, but those are now conveniently digitized. And that has certainly transformed matters in terms of access. I remember some maybe 8 or 10 years ago, maybe a little more, I was lecturing in my class, one of the same classes that friend Aparna Balachandran attended one time. And I had referred to some legal case. I referred to the case, but I couldn't exactly remember the year. And I was giving a broad summary of the judgment, and suddenly a student in my class put up her hand and then gave me the exact title of the case, the year, the name of the judge, and started reading out the judgment. I was quite amazed, and she said she just got it on the laptop because all of it is now apparently available. This is, and I didn't know this at the time, but digitization obviously has improved all of these matters. So if that is the case, why take the trouble of going into these archives, district archives, and putting them together and digitizing all of that material? What use is it? And those records, as Justice Muralidhar was just pointing out, in the district courts, are in a state where they are very often not even worth pulling out those papers. They crumble. In fact, I remember in the 1970s, I was telling Prabhu this incident last night, yesterday, this morning, right? Midnapur District Court, this is 1970s. I got permission to go and look at the record room there. And the person who opened the record room, he said, "Be very careful, there are snakes in there." So that is the condition in which a lot of these records have been kept. So the question will obviously arise, why take the trouble of doing this? What use is it? And it just struck me when I was thinking 2 or 3 days ago about what to say. It just struck me that the recent Law Commission report on the sedition law has made an interesting observation. Now, you know, some of you don't get alarmed. I'm not going to open up this whole question of the sedition law. I have my views on it, but this is not the place to discuss it. But the Law Commission in that report makes the observation that the charge that is often made, that the sedition law is a colonial law and therefore should go. And the Law Commission said that that is not a valid ground for its repeal, because by that account, the entire Indian legal system is a colonial legacy, just as is the police or the civil service. So why is that necessarily? Should all of that go? And the argument of the Law Commission is, it makes a very interesting claim that the colonial origins of a law are by themselves normatively neutral. Okay? So What should count is whether the law is required under our present circumstances or not. Now, I don't agree with the claim that the law is, that the political origins of a law is normatively neutral. I don't agree with that. That is not true. That is true not only of colonial laws, but also of those made by our Constituent Assembly and later on by Parliament and the state legislatures. Each law is a decision made after considering various contending normative claims. Each law is a decision, therefore, made after those different claims have been discussed, and then a particular decision is made. That decision is not normatively neutral. It is contingent, and it is subject to change later on, right? So the question, therefore, for instance, I was reading the Constituent Assembly debates recently, and one of the big debates was whether or not the ICS should be retained. And a very large number of extremely prominent Congress members of the Constituent Assembly actually made a very, very passionate argument that the ICS is an enemy. That was an enemy of the national movement, and it should be thrown out. And Vallabhbhai Patel made an impassioned intervention, telling his own party people. He said, "Do you want me to run the country with Congress volunteers? We need experienced civil servants who know their job, and that is how the state must be run." Now, there are contending, as you can easily see, there were very strong grounds on the other side to say these were the people who were opponents of the freedom movement, who actually suppressed the freedom movement. Why should we continue with these old officers? And on the other side, the decision was made to continue with them. The question, therefore, is, under what circumstances and on what basis do we make those decisions? If you actually think of the colonial institutions, just as it is true that a lot of the colonial institutions were in fact retained, there were a lot of institutions which were not retained, right? They were actually abolished. For instance, the king in parliament doesn't exist. The Privy Council, which used to be the final court of appeal, we have got rid of it. We have a Supreme Court in its place. We have put in fundamental rights, which did not exist in the colonial system. We put in adult suffrage, in spite of the fact that even in the constituent assemblies, there were lots of members who expressed doubts about whether or not such a system would work in a country with such massive illiteracy. Will adult suffrage work? But we still had it. We got rid of separate electorates. We kept the high courts but separated the judicial and administrative functions at the district level, right? In the colonial times, they were both fused into the office of the district officer. We abolished the jury system, which actually existed in the presidency towns because the Europeans did not want to be judged by Indian judges. We abolished institutions such as the criminal tribes, for instance, right? So to understand why we have kept some colonial features and got rid of others, we have to look at how the colonial system functioned, not only at the top, but at the district and local levels. And for that, the summary accounts we get in High Court judgments is not enough. Actual judicial archives are an invaluable source for evaluating the effects of colonial laws on the political and social life of the country. That is the basis on which decisions were made and still have to be made on whether or not to keep particular colonial laws. So this is something that has been of interest to lawyers and legal scholars who have contributed to public debates for legal reform, right? Both for keeping certain colonial institutions as well as for getting rid of them. But the judicial archives have been of great interest also, not just to legal historians, but to social historians of India. And let me take the rest of my time to point out a few of these. How, in fact, judicial records have been an invaluable source for a great deal of social history that's been written in the last decades. So, the first thing, I'm making fairly general points. Caste, kinship, family, and community structures at the local level. Judicial records, and therefore the records of various, both civil and criminal cases, are an invaluable source because these are written testimonies, and if you can, district records, you are able to see actual evidence material, witness testimonies, reports, etc., etc. Since many criminal cases involve violence, murder, feud, arson, etc., etc., they provide images of power relations at the local level that is very hard to get. You do get them from administrative reports too, but judicial reports, I'll just come to this, why the judicial reports in a sense at the local levels are so interesting, because in a sense they give you points of view that are different from the simple administrative summary. You get other points of view which are there in the various witnesses and other kinds of testimonies of people ranged on a whole range of roles at the trial court. Civil cases, for instance, involve property disputes or violation of contracts. And so they shed light on wealth, property, business, labor, and other economic and social aspects. And in this connection, let me just give you a very brief point about the Bhaval Sannyasi case that Justice Muralidhar mentioned. It took a lot of work on my part to get the material for that case, and I was just explaining to Justice Bhat that, in fact, I did not have access to the court records because even though the evidence, and the evidence was huge because there were 1,300 witnesses in that case. And so the evidence amounted to evidence was actually printed. 20 copies were printed in 15 volumes for the High Court appeal. But I was not able to, well, I was able to see them because they were not available in the High Court records. I just could not get any access to it, even if they do exist. But I was able to get them in the house of one of the litigants in that party. The family still owned that set of 15 volumes. But I couldn't actually go there every day and make notes. So the advantage of that case was, because it was so sensational at the time, each day's trial proceedings was reported verbatim in the newspapers. So actually I got all of this from the newspaper reading room of the National Library in Calcutta, where the entire case the trial actually ran for nearly 3 years. So all of it was actually taken from there. I had an assistant who dutifully copied. I would mark out pages, and she copied this out. That's how I got access to. But just think of how much easier it would have been if that whole thing would have been available to scholars. Now, let me turn to some other social institutions for which, again, the judicial records are possibly the most valuable source. The history of religious orders and sects. Now, the control of temples, mosques, endowments, all of these, perhaps the most reliable source is still judicial records, because in fact every major temple or Waqf endowment in India has had court cases. So they've been taken to court for one reason or the other. So I know, for instance, the Jagannath temple in Puri has lots of court records around it. The Bodh Gaya in Gaya, so there's the whole dispute over the Mahabodhi society when they claimed Bodh Gaya as a Buddhist, and that went into court. There is the Tarakeshwar temple in Calcutta, which again, there were both civil and criminal cases involving in that Tarakeshwar. So there was also the famous agitations of temple entry with regard to Dalits not being allowed, and we know in different courts of law there are enormous details about specific supposedly religious injunctions on who is allowed into the temple, who is allowed how much, what is the distance from the deity that has to be maintained by different castes, the various times where they would be allowed. All of these go into legal cases, and even the legal judgments are affected by this. It's an enormously valuable window into the actual state. So this is not dharmashastras or the textual material that you get in religious scriptures. This is actual practices at the local level that you get reflected and reported in the courts. Let me turn to gender relations. And once again, if you look at the social history on gender that we have in India, a very large part of the evidence comes out of judicial records. So whether it's sati, widow burning, or child marriage, the whole debates and history that you now have on the role of patriarchy, changing forms of patriarchy in India over the last 200 years certainly, women's property rights, different castes and different religions, all of this, again, adoption is another, judicial records are absolutely an invaluable source. Some of you may have come across an article by the historian Ranajit Guha, who passed away recently, an article called Chandra's Death. I don't know, some of you would probably know it. It's an amazing article which is based on testimonies by women. This is 19th century, rural. A woman who actually died because of a failed abortion attempt. The police actually went and got testimony before she died, and there were testimonies of women in the family, and this record actually was not in any district records. This was in a collection compiled by a literary scholar of samples of early Bengali prose writing. Because this collector, he was collecting in this rural area, he was collecting from various houses whatever old written material they had in the house. And there he managed to find these 4 or 5 fragments in Bangla of testimonies of these women, which were recorded and then produced in court. It's an amazing story, but it was constructed entirely out of these 4 or 5 fragments of judicial records. There's also, in the Orissa case, social and political conditions in the princely states. Now that's a separate topic altogether, because the conditions in princely states were not necessarily the same as in the British Indian provinces, because the legal and political conditions were quite different. And again, princely states, some princely states do have their own relatively well-preserved documents, but most did not. And so if there are court records involving princely states, they are very often will give you information which you will not find in any other source. As I said, district court records often preserve testimony in the original language, right? Not translated into English, which will always be the case in the High Court records. So many famous testimonies in court have come to us in English translations. For instance, the famous testimony of Birsa, the Munda chief. We read this in English translation. But just imagine what it might be if we could find in some district court the original testimony as he must have spoken it in Mundario. I don't know exactly how he spoke it. How much more revealing and nuanced would be such testimonies in the original if we could find records from the district courts. And finally, a major form of dissemination of the law in the public domain has been through crime novels and courtroom drama. Now, every language in India, a very major part of popular literature involves the courtroom, the judicial system, and detection and policing, detective novels, crime novels. Now, in the era of print, it was the detective story and family drama fought through litigation. You know, the breakup of the old joint families and extended families. A very large part of that history is recorded in literature in the form of courtroom drama, property disputes taken to court. So you have the wily lawyers, you have all the middlemen, you have judges, all the intrigues and so on which are played out. That is the stuff of a great deal of popular literature and then taken to the world of cinema. The courtroom drama, if you look back on, well, I'm familiar with the Hindi cinema, enormous numbers of major blockbuster movies which depended crucially, the drama was in the courtroom. Now, if we had judicial archives to tell us, it would provide fascinating ways to track how the material of the actual legal process was transformed into the narrative forms of fiction and cinema. Because they have been transformed. They're not the same. And there is some work on this which has been done particularly by film theorists and so on in more recent times, to see what it is about the courtroom that makes for telling drama and what attracts the popular imagination there. It's a very major part of trying to understand the place of the legal system and the legal institutions in the broader social arena of Indian life. That the position of judges and lawyers is made not just by those who actually encounter the legal institutions, but actually by people who don't encounter the legal institutions directly. It's there that the image of law and lawyers are, so for instance, the standard phrase, law will take its own course, or justice is blind, and these kinds of very simple statements, they have very interesting but often deep-rooted understanding in the popular imagination. And one of the things that social historians now that a lot of historians take the actual, what is termed discourse, the actual texts, the actual textual practices in the legal profession. Take that seriously. Try and understand what those words mean, often the very peculiar languages of the law. What transformations are made when those are translated or transmitted into the popular domain, either through the newspaper reports or these days, of course, television and the popular literature and cinema. So these are the range of things I think that become relevant when one asks the question, why are judicial records important, and why should someone like Justice Muralidhar take the trouble of organizing and putting together an archive as well as a conference of this kind. So I'll end there. Thank you very much for listening to me. Thanks.
Thank you, sir, for sharing your insightful thoughts on the social life of judicial records. May I now request Honorable Sri Justice Shripathi Ravindra Bhat, Judge, Supreme Court of India, to kindly present the presidential address. My Lord, please.
A very good evening to all of you, to Justice Dr. S. Muralidhar, Chief Justice, Justice Dash, Justice Panigrahi, Dr. Chatterjee, Judges of the Orissa High Court, distinguished archivists, ladies and gentlemen. I must confess great diffidence in speaking after such a scintillating and luminous speech by Dr. Chatterjee. But since I have been asked to make this address, I will still endeavor to do so. Thank you very much for such a warm welcome in Orissa. I am also happy to be here on this momentous occasion. I feel really fortunate because this is one thing that very, very close to my heart. A judicial archiving and museum project is something which I dreamt of, but I see it happening, and that under the leadership of my friend is something that makes me not only very happy but very proud. Thank you very much, Chief Justice. It is a tall task to ask a judge to speak after such a celebrated and prolific historian like Dr. Chatterjee on the topic of judicial history, preservation and archiving. Firstly, I extend my heartiest congratulations on the completion of the release of the first volume of Judicial History of Odisha. I must also express sincere gratitude to Justice Muralidhar for championing what must have been a Herculean effort by him and his team to not only identify and catalogue, but also begin digitizing these numerous manuscripts and documents. They are sure to survive as rich resources for historians, scholars, and others, not just interested in our past, but also those invested in the understanding of our present and future pathways. I am further delighted that the Judicial Archives project has been conceived and is being executed under the guidance of the Chief Justice. His work in conceptualizing, ensuring resources and manpower to preserve and archive these records and digitize them is pioneering, and I think sets very, very high standards, a very high bar for future efforts in similar places elsewhere. The themes laid out: ancient justice, freedom movement, the tribal systems of justice, history through judgments, accessories relating to law, the objects that we all see and take for granted every day but through the ages, and justice and eminent people and jurists are well thought out. History, legal or otherwise, is a passion that I fervently enjoy engaging with. As a member of the editorial board of the Courts of India publication, which came out in 2016, I first-hand participated in research and writing process of a book that was ambitious in its sheer scale of coverage. The difficulties we encountered of limited sources, unorganized material, lack of awareness locally, and lamentably what Dr. Chatterjee mentioned, even amongst our own archives, getting some of those records was very formidable, are ones that I am confident will disintegrate if courts around the country take inspiration from the efforts taken by Odisha. Legal history is not limited to what courts hold, but far more multifaceted. I only echo what Dr. Chatterjee said. It is informed by the forms of governance, how law and order was maintained, the organization and distribution of power through the centuries. The sources of this history are diverse and range from edicts, copperplate grants, palm leaf manuscripts to records of essential commodity laws, taxation methods and parameters, etc. A vast majority of our known legal history owes an immense debt to rulers and administrators that prioritized rampant record keeping. So we are able to dig the past, although there are other challenges, either through their own indigenous administrative setups or by extending support and being patrons of travelers that came from far and wide alike. Texts from the 18th century onwards are pivotal in tracing the colonial legacies as well as departures in the modern legal system that was at the time being newly built. For instance, after the conquest of Bengal in 1764, the officials of the East India Company were confronted with the question of how to rule. Convinced that the distance between the British and Indian society was too vast to bridge, they used religion as the key to their understanding. They built a legal system that drew heavily from religion. Initially, Brahmins and Maulavis were seen as authoritative lawgivers of Indian society and were incorporated into the new company courts. This was followed by a systematic translation and compilation of Hindu and Muslim religious texts to serve as codes of law. Diverse and flexible traditions of religious and social life were frozen into the regularities of a modern legal system. So we have lost a lot of our richness. Brahminical and orthodox interpretations of scripture were within Indian society, they were granted the status of law. In many ways, by creating law in this manner, they were transforming the role of religion in social life as well as imprinting religion on the new legal system. The transformation of law and society were wide-ranging and significant. From property to the family, from religion to labor, we continue to live with many of its consequences. Understanding how this came about has been the result of meticulous work of numerous historians who had the benefit of archives containing records not limited to court judgments, but also administration documents and communication between individuals in the East India Company. Scrutinizing these types of primary sources has meant a far richer understanding of the intentions and actions of the times. Their work has since revealed that the story of modern India's legal system was the result of numerous accidental actions and ironic outcomes, a history that I will briefly trace by referring to just 3 individuals from the colonial legal and administrative setup. India posed a unique problem to the colonization campaign of the British, who had grown accustomed to, which the British had grown accustomed to. Unlike North America and the Caribbean, India had a language gap and a local traditional and customary law, resulting in the failed attempt by the British to impose their own laws. They then turned to the Nawabs of Bengal to understand how an Indian state functions. Spearheaded by individuals within the British administration, the colonization strategies changed. There was a renewed focus on Indian knowledge and experience, steeped in textual traditions. Warren Hastings was the first such individual. He encouraged the study of Indian languages, traditions and systems to evolve an indigenous setup alongside British sense of justice and discipline. His model was India as a theocracy. He focused on the ancient constitution by relying on 11 of the most revered Pandits of Bengal to compile Shastric law for the use in the company's courts. The resulting code of Gentoo laws or ordinances of the Pandits 1776 covered subject areas as wide as debt, inheritance, civil procedure, slavery, master-servant relationships, fines for damaging crops, theft, and so on. Then we had Sir William Jones, the co-founder of the Asiatic Society of Bengal and a judge in the Supreme Court of Judicature in Fort William, Bengal, whose reliance on ancient texts was so severe that he refused to trust even Indian scholars and their translations. He created the Digest of Hindu Law on Contracts and Succession to ensure decisions were made according to Hindu law without any corruption by Pandits and Brahmins. Next is Colebrook, who is considered to be the first great Sanskrit scholar of Europe and was initially posted as a judge in Mirzapur by the East India Company. He developed a different conception of the nature and function of Hindu law. Much like Islamic law, Colebrook sought to divide Hindu law too into schools: Dayabagha, Mitakshara, Banaras, Mithila, Maharashtrian and Dravidian. He tried to remove the religious portions in the Hindu texts and instead focused on developing a civil code. He was able to do this from a deeper appreciation of the distinctions in the Hindu scriptures. Similarly, with Islamic law, influential opinions and commentaries were translated rather than being seen as a way of life. These traditions were elevated to rigid codes of law. This was only excavated by the creation of textbooks. Menofton, for instance, compiled a number of fatwas in 1825 with his own generalization under the title of Principles and Precedents of Mohammedan Law, which the English courts began to rely upon. This made Sharia law something it fundamentally had never been, a fixed body of immutable rules beyond interpretation and discretion, and made it binding regardless of whether people actually treated it as such. This interaction between administration and identity has given scripturalist Islam an enduring quality long after the post-colonial period. By the early 19th century, India's legal history reveals a new framework of disputes among local and regional elite who used the new court systems to reinforce dominance and power. In many ways, it drew the lines more deeply between different social groups, landed gentry, merchants, etc., because it now played a role in all aspects of life: marriage, inheritance, production, labor, and land. There were now punishments for crimes against private property, new rules of evidence, and codes of procedure that replaced Islamic law. For instance, all depositions and examination of witnesses began to be transcribed and translated, and this text was legally binding rather than the oral testimony itself. By thinking that indigenous norms could be used in British institutions without compromising either, the result was that the plurality and diversity of our cultures were overridden. Internal contradictions, distinctions, subtleties, and nuances were ignored in the interest of a more or less homogeneous legal system. The flexibility and the power of interpretation were glossed over for the interest of certainty and rationality. Rather than trying to reconcile conflicting interpretations through meaning and intention, the new legal system looked for precedent and used it as analogy, leading to the common law system we now follow. While Hastings and Jones were committed to searching for an ancient Indian constitution, in the process, ironically, they and their successors, like William Bentinck and Macaulay, turned customary law on its head and unwittingly achieved what they sought to avoid the most: English laws as the laws of India. Their search for indigenous law led to its expropriation, its transformation, and the elevation of these textual aspects over customary law, and finally its rigid codification. These are all foundational aspects of our laws and legal systems in certain spheres that we now take for granted. For good or bad, however, their origin story is an important one to tell. The colonial project of laws, though not intended by its architects, delinked the people from their own indigenous roots through the importation of common law and the introduction and spread of English as a medium. Customs followed by tribal communities were overlooked. Islamic law, as I said earlier, was codified, and common law methods were applied universally. The courts began to categorize and used analogies with the adoption of precedents. The British judges were able to do this because full schools of diverse thoughts were universalized through so-called experts, the authenticity of whom itself was questionable. The markers of the sources of history offer value and have also undergone dramatic change. For instance, the William Jones era prioritized age as the reason for sacredness and in turn authenticity. It focused on Sanskrit sources under the assumption that they were the most authentic reflection of law. We now have so many newer conceptions of what makes history and how it is depicted and disseminated. The focus on subaltern, oral histories and vernacular texts are some examples of this. A peculiar and unique aspect of India's history, as I said earlier, is not only its antiquity, but also the mediums on which it is preserved, which is rock edicts, palm leaves, scrolls, copper plates, even temple engravings, and lastly, paper. Before I conclude, I just want to quickly share something that piqued my interest when I was researching for this speech. Odisha's immense contribution to the freedom struggle, a history that I find does not receive the mainstream attention in other parts of the country. I learned that Odisha is the birthplace of several feminist freedom fighters, such as Kuntala Kumari, Sarala Devi, Rama Devi, Malti Chaudhary, and Annapurna Maharana, to name a few. Many of them were imprisoned during the struggle and participated in breaking salt law. They were women from diverse economic and linguistic backgrounds, deeply committed to social reforms such as prohibition, economic and emancipation, and widow remarriage. And many used writing, poetry, and other artistic mediums to spread their message on repressive laws and regulations. And we have Sudhanshu Bala Hazra, whose claim as the first woman lawyer has now been recognized. Her case was espoused by the great Madhusudan Das. I hope that more historians are encouraged to research and write about these fascinating characters and episodes in legal history, both inside and outside the courtrooms, in accessible mediums. For these are the histories that will help us understand law and society, the push and pull of reform and transformation contextually. Thank you very much.
Thank you, my lord, for enlightening us about the historicity of archiving and putting all the landmark events in perspective. Thank you, my lord. As a symbol of our reverence and gratitude, we would like to present memento to honor our honorable dignitaries. May we now request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly present memento to Honorable Chief Justice Shripathi Ravindra Bhat, Judge, Supreme Court of India.
May we now request Honorable Shri Justice Debabrata Das, Judge, High Court of Orissa and Chairman Record Room Digitization Center Committee to kindly present the memento to respected Professor Partha Chatterjee, Professor Emeritus of Anthropology, Columbia University and Honorary Professor, Center for Studies in Social Sciences, Calcutta.
Gratitude makes sense of our past, brings peace for today, and creates a vision for tomorrow. As we now proceed to the end of the inaugural session, may I now request Honorable Dr. Justice Sanjeev Kumar Panigrahi, Judge, High Court of Orissa, and Member, Record Room Digitization Center Committee, to kindly deliver the vote of thanks. My Lord, please.
Good evening, everyone. The chief guest of the evening, Justice Shripathi Ravindra Bhat, and respected Ma'am Bhat, Chief Justice Dr. S. Muralidhar, and Madam Usha Ramanathan, Justice Debabrata Das, Chairman RRDC Committee, and my esteemed brother and who are pillars of strength of RRDC Committee, Justice M.S. Sahu, Justice Sasikant Mishra, Justice B.P. Shripathi, Justice S.K. Mishra, and all the brother and sister judges present here. Many eminent historians who have come from different parts of the country, eminent historians of our own state, Professor Partha Chatterjee, who has mesmerized us with his great speech, and other distinguished dignitaries, officials of the state government, and all other dignitaries who are present here, ladies and gentlemen. No duty is more urgent than that of returning thanks, and therefore I consider it a great privilege to propose a vote of thanks to all the dignitaries who have made it convenient to attend the National Conference on Judicial History and Archiving. The need of the hour is to instill a sense of history and to nurture scientific temper, more particularly in the Indian judiciary. It has been an enlightening and informative event that has brought together some of the greatest minds of Indian history and law. I would like to extend my sincere gratitude to our distinguished panelists, keynote speakers, and moderators for their contribution to this conference, and they will try to have a breeze between law and history. Our speakers have provided us with a wealth of knowledge and insights on the history of judiciary. They have explored the evolution of judicial systems, the role of judges in the society, and the impact of landmark cases on legal precedents. Their presentations have challenged our assumptions and deepened our understanding of the law. I would like to thank the organizers for the conference for putting together such a well-structured and engaging program. Their generosity has enabled us to bring together this esteemed group of legal professionals and scholars, and also professionals and scholars from history, to share their knowledge and experience. They have worked tirelessly to ensure that every session has been thoughtfully curated, every detail is being attended to. Their dedication and hard work have brought up to this stage, and I hope this will be a very successful one. In the end, I believe that this conference has demonstrated the importance of understanding the history of the judiciary by exploring the origins and development of our legal institutions. We gain a deeper appreciation for their vital role in the maintaining a just and equitable society. Our history records and archives are witnesses to the past. They provide evidence, explanation, and justification both for past actions and current decisions. Archives enable society to undertake a wide range of roles that enable civilized communities to take root and flourish, from the enabling education and research to protect human rights and confirming identity. Archives are unique, contemporaneous records, and so once lost cannot be replaced. It is only through proper identification, care, and wide access that the vital role that archives has can be fully realized to the benefit of humanity. And our Archive Center is a testimony to that. An objective pursuit of history, such as our best historians have attempted, require an impartial mind of a judge and not the mind of an advocate. We must keep our eyes open for unfamiliar idea and be ready to consider a range of different inferences or assumptions. Let's feel pride in our tradition of argumentative Indian, not the intolerant Indian. I am grateful that such a project could be started under our Chief Justice, Justice Muralidhar, whose able leadership has brought us to this stage. I hope that the insights shared here will inspire each of us to continue to explore and learn from the rich legacy of judicial history. Thank you again for your attendance and participation in this conference. I wish all the sessions to be very successful, learning and enjoyable. Jai Hind. Thank you.
Thank you, my lord, for your kind words of appreciation.
May I now seek the leave of Honorable Chair to declare the inaugural session closed? Thank you, my lord. The inaugural session is declared as closed.
I request all the honorable dignitaries on the dais, honorable judges, discussants and paper presenters to kindly proceed to the portico of the Odisha Judicial Academy for a joint photo session followed by dinner. And for the information of the participants and delegates, the tomorrow's technical session shall commence at 10 a.m. Thank you.
Thank you.